Was this an internal violation of policy and procedure, or was it a criminal act? Well, we know Tasha K did a video saying she showed jail records to the parents of federal witnesses, as well as gave the federal witnesses directly jail records. That is a crime. That is tampering with federal witnesses, and we know as a result of that, witnesses flipped, which influenced the outcome of a trial. Those are 1,000% federal crimes. Tasha K could not have shown jail records unless she had jail records. Where did she get them? Officer A. So Officer A was an accessory to the crimes. She was an accomplice, a co-conspirator. She aided and abetted the criminal activity of Tasha K. Tasha K could not have shown jail records if she did not have jail records. So Officer A, once she passed those records to Tasha K, that may have been a violation of policy and procedure. Once Tasha K read them on air, Officer A was still guilty of a violation of policy and procedure. The minute Tasha K crossed the line and contacted federal witnesses and federal witnesses' family and passed that information on, that's when it became federal crimes. That's when it became witness tampering. That's when it became influencing the outcome of a federal trial, because we know the witnesses were influenced by seeing the jail records. Officer A unquestionably broke the law. It may not have started that way, but it ended up that way. So Officer A is guilty of criminal behavior. She unauthorized accessed 153 times the jail records. Whether she was authorized or not is not the issue. Whether she had permission or not is not the issue. Whether she passed it to a blogger is not the issue. The issue is what the blogger did with the jail records. She took those records, sent them to federal witnesses, tampered with federal witnesses, influenced federal witnesses, and influenced the outcome of federal trials. She couldn't have done it without the jail records. She didn't have phone numbers without the jail records. She could not have contacted people without the jail records. The jail records were the tool used for Tasha K to commit her crime. And who gave her the tool? Officer A, which means Officer A is guilty of federal crimes by proxy, by default. Had she not given those records, they could not have been used to flip witnesses. So, yes, Officer A did break the law. Yes, Tasha K did break the law. And yes, this is federal crimes. It is more than a violation of policy and procedure, because if that's all it were, it would have gone to Human Resources. You don't send something to the Department of Justice unless it's more severe than that. Once they investigate, there's no need to seal documents if it's not a serious crime. And when you withhold those documents from defense counsel, we understand the severity of the crime. Anyone with half a brain, with a functional brain, with a brain that operates, understands very clearly passing jail records to a blogger who used them to influence, tamper with federal witnesses, broke the law. Aiding and abetting is a criminal activity. Being accessory to a crime is a criminal activity. She didn't have to give the records directly. She did it indirectly. Whether it was with her knowledge or without her knowledge, Ignorance of the law does not absolve you of the law. The law broke the law.